So my talk today is about your electronic devices at the border, kind of what's going on with the border search exception. Today is August 4th. I don't know about any of you, but I cannot believe summer is almost all over. So a little bit about me. Oh no, I went to the next. Of course. Keynote crashed on me, so we're reopening. Hold on. I don't know what happened. No, I have this jinx, guys, that every time I present, something goes wrong. So okay, I have my one thing. So hi, guys. It's August 4th. So a little bit about me. This is me at Lego Robotics Camp. I think this is the first time I ever coded anything. But interestingly enough, I went on a path to become a lawyer. But after that, I decided, hey, I'm going to go do some computer science. So I'm at the University of Illinois in Urbana-Champaign, getting my master's in computer science with focus in computer security and digital forensics. I do all sorts of things around privacy, et cetera, et cetera. But because I'm a lawyer, I have to put this obligatory disclaimer to make sure you understand that I am not your lawyer, that this presentation is not legal advice, although I wish I could give all of you some interesting tidbits personalized to you. Unfortunately, that would not be a good idea. So, not your lawyer, not legal advice. So, I really like this photo. I think it's from The Onion. But no matter how you choose to re-enter or exit the United States, you'll have to cross the border. And that means that the border is kind of a heavily traveled piece of the United States. So roughly 10 million out of 448 million people were inspected in 2002. So these are old numbers, 10 years old, and were subjected to a more invasive secondary inspection. So it's not just crossing the border, but being pulled aside for a secondary inspection. And then some more numbers here. We have between October 1st, 2008 and June 2nd, 2010, about 6,500 people had their electronic devices searched when crossing the United States border. So this is, 2008 to 2010. I can imagine now that people have more and more devices. Your company, well, I'm sure all your companies have been up to par for a while, but as other companies have started issuing more and more electronic devices for their employees, more people are carrying electronic devices, and the search numbers have likely increased. So what should you know when entering the United States? Well, first of all, the Customs Border Search Patrol considers 100 miles within the border of the United States, and this also includes international airports. And this lovely picture is from the ACLU, and one of the things I've wanted to do to modify it is find every major international airport and then draw 100 miles, because I'm pretty sure that would be the entire United States. But if you weren't aware, the border also includes international airports. So what is the border search exception? Well, first of all, officials rely on it to search, review, copy, detain cell phones, computers, other electronic devices. That means cameras, etc., without a warrant, without suspicion. And I'm sure you're all thinking, well, what about the Fourth Amendment? And the interesting thing, so before I go into, what is the border search exception, we'll do a little review about the Fourth Amendment. And the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. That means a neutral party must establish that there's some sort of probable cause to issue a warrant for an individual to be searched. So that's the general rule that you have protection over your devices when you're within the United States. What is probable cause? And that's where there's a belief that a crime has been or is being committed, and that the items that they're going to search or seize are connected to the crime. So, I have a law professor who would probably get angry that I use these numbers. There are no set numbers for suspicion. Generally, probable cause, I would aim it at around 45%. I think it's easier to So that means you don't even have to be 50% sure that something is there. 45% sure is fine. Worth noting is reasonable suspicion, which if you're not familiar with, will come up again, and as you can see is a lower level of suspicion needed to get a warrant. So I really like this cartoon. Anywhere else, United States, and it says be prepared for full body scans, pat downs, etc. So the border search exception is one of many exceptions. Generally, there's not a search if informants wear a wire, private actors decide to turn over information to the government, undercover officers, phone companies, internet, or other companies, you may have heard about this in the news as being a thing, relied upon by the government to gather lots of information. Consent is also another where the government doesn't believe it's a search, or it does not constitute a search. And then we have plain view and border search that fall under this. Also under these, no warrant needed, is the search incident to arrest, which I'll briefly touch upon. There's a question. We can go free form. Let's go. They're not searches. They're considered not searches by the courts. And so plain view and border search, it's kind of unfair for me to put this all in one slide because they really are not a search and then exceptions to the search requirement. But I thought it would give you any idea of kind of where the government can tread without a warrant. Border searches are an exception to the Fourth Amendment. So interestingly, the border search exception has been around for a really long time. Congress passed the act in July 31st, 1789, not long after they passed the Fourth Amendment. Interestingly, there was discussions about the border search as an exception prior to the Fourth Amendment even being passed, meaning they intended this to be part of the Constitution, and depending on how you interpret the Constitution, many would argue this is the intention of the original founders, and therefore we should abide by it. There are lots of good reasons for the border search, but in particular, electronic devices are causing some interesting issues to arise. So there's a government interest generally in protecting the United States, protecting what comes into its borders, being able to do random searches, which is codified in this statute here, which basically gives the border agents the actual authority to go through your stuff and search you when you reach the border. So the border search exception, or the border search doctrine, has been expanded. Generally, although it was a limited exception, the court expanded the doctrine in 1977 in United States v. Ramsey. The court ruled that border searches have been considered reasonable even before the adoption of the Fourth Amendment, and there's never really been any additional requirement that the reasonableness of a border search depend on the existence of probable cause. And since 1977, the border search doctrine remains pretty much undeveloped. So if they find that a search is considered routine, it's basically no form of suspicion is needed at the border to do the search. So what's routine? Courts rarely find that the border search is not routine, meaning most of the searches that are happening at the border, a court is going to agree is routine. But are there any limits on this seemingly very broad doctrine? Good news, strip and cavity searches are, you need reasonable suspicion. So if we go back to that chart I had, I don't know, 20 slides ago, 5 slides ago, basically that's 35% or 30%. Probable cause, which is needed for a warrant, is about 45%. So just for a non-routine strip or cavity search, you need the lowest form of suspicion to actually conduct that search, which is kind of shocking. But at least it is a limit on this broad search. Yes?
I hate to have to ask this, but TSA makes this actually reasonable. Are there now routine cavity searches?
No.
So all strip and cavity are not routine?
Yes. Yeah. It's not like the government can go in and say, hey, every fifth person is now subject to a cavity search, therefore it's routine. Privacy rights seem to be like that sometimes, but that is not exactly how routine works as far as border or TSA claims. So, oh no, gosh, guys. Okay. Whew. No. Oh, it's a short connection. Okay, don't touch it. Now I lost my place. The border search is permissible, may be invalid where consideration of race, the purpose of delay, or manifestation of ill will. So the courts are going to say, if you're pulling out every person because of their gender, maybe because of their age or their race, a court could find that that is invalid when it might otherwise be permissible. So let's go roughly into what is routine, because I'm sure you're going, has this thing that's happened to me, is it routine? So not routine, strip or cavity searches, race, purpose of delay, manifestation of ill will, which I talked about, fingerprinting, photographing, physical force, frisking, searching groups of U.S. citizens are all considered routine. Luggage, personal belongings, jackets, wallets, etc., and electronic devices are also all considered routine. So basically, it's very, very broad. Yes? Physical force, I believe that is, forcing you to comply if you're resisting, probably. The court didn't, this case in particular, I haven't read in a long time, but generally they can use force to force you to comply to a search, even if that means putting you in handcuffs, etc. So what are the rationales to protect the United States? Well, violent jihadist material, information about cyanide, nuclear material, video clips of explosive devices, pictures, etc., child pornography, IP rights violations, possibly in the future, depending on how Wassenaar goes, hopefully not. But those are some considerations, but generally the idea is just to protect the United States. I really like this photo. This is a border official searching the insides of each pepper. I guess there was some sort of smuggling that happened where they were hiding. There have been some very clever, creative ways to hide things while crossing the border. Do a Google image search. It's kind of worth chuckling about. So, again, I want to reemphasize that a U.S. citizen returning to the U.S. state has the same Fourth Amendment rights as a foreign citizen. None. So you've left, you're trying to come back in, you're on the border, you basically are treated just like everyone else, and you have no rights at the border with regards to the Fourth Amendment. So a lot of people say, why do I care? I have nothing to hide, which they're always one of those in the group. But border searches can compromise sensitive professional information, trade secrets, attorney-client or doctor-patient communications, personal correspondence, and documents. A really interesting thing about this is, as an attorney, the border, you can't claim attorney-client privilege at the border to stop them from searching or looking through something. So you are putting potentially at risk client data or whatever you may have that might be covered under attorney-client privilege at risk by bringing it across the border if they choose to search you, because some border official could be rummaging through and photocopying, taking those documents, etc., which you may not have access to in the future if there's a delay. So part of the border search is that they can take and copy and hold on to documents and other possessions that you may have with you while crossing the border for what they say is a reasonable period of time, but that's been as high as 40, 50, 60 days. So if they're important client documents, you may not have them. So I think that's really an important thing to press, that even something as high regard as attorney-client here is still under the subject of the border search exception. So the Supreme Court of the United States has been giving various indicators that there is going to be a shift in the way that electronics are handled with regards to the law. First of all, it's great to see that one of the justices understand that the Fourth Amendment is being affected by the advance of technology, and I thought that was worth pointing out. So, is searching an electronic device different? Well, it implicates different privacy concerns than the search of containers. Many of you have heard the general, it's a gateway to other devices. You all carry lots of electronics. I'm sure you all know the increased privacy concerns. But generally, if you think about when the border search exception was created, it was whatever you could carry with you on your person or whatever you were shipping in a shipping container, and that was being searched. Nowadays, it's kind of a gateway into other people's lives as well as items or things that you may keep on other computers, on the cloud, etc. And so do the traditional rationales that were created around the Fourth Amendment's border search exception really still apply to electronic devices? I also really like this picture. So they hold a lot of things. So U.S. Customs and Border Protection, they can read, search, copy, retain, I said this, for a brief, reasonable amount of time at an off-site location, which means you will lose access to them for a period of time if you do not have another copy. Again, it's unclear how privileged documents are handled. Sometimes I've read that they will handle them in a special way, but once they leave your possession, how can that be guaranteed? So the Customs Border Control or Patrol encounters encryption or technical difficulties. Well, generally, the data of the device is sent to other agencies to help. Unclear if cooperating agencies can keep that data indefinitely. So you can imagine you have an encrypted computer and you're like, good luck, my computer's encrypted. They will likely, if they choose, take that device, make a copy of the image, or image the computer, and possibly give it to other devices to try to crack. What happens with the copy that is made is also unclear. So they can be kept for weeks and subject to forensic searches. But at what point is this an extended border search? And, if it's an extended border search, and that goes, along the lines of like a strip search is an extended border search, you need reasonable suspicion. And so at what time does that really cross over? The system is also bizarrely easy to bypass. The U.S. mail has pretty heightened protections. They need a warrant to get access to first-class mail. Granted, it's x-rayed and photographed, et cetera. There are certain things that do happen to it as it travels. But for a while, journalists were recommending people who were fearful in traveling with the border with sensitive documents to just mail them to themselves because it was less likely that that would be subject to a search. Don't know if that's necessarily true, but it seems like it's an interesting, problem that exists here where the protections exist in some forms but not in the others. So will it change? Before I go into the will it change, I'm going to go through this really quick outline. There are two cases I'm going to talk about. One is a Ninth Circuit case, which is California, Nevada, Arizona, Washington, Oregon, and maybe someplace else, that ruled it that they decided in 2013 of March. They submitted it to review to the Supreme Court, and it was denied. So the holding for this case stood. And then another court decision involving the search incident to arrest, so another exception, meaning they could search your electronic devices when you were arrested, was granted review by the Supreme Court just 4 days after Cotterman was denied, which I think is very indicative to the way the court is thinking. So finally, Riley was decided in June of last year, and so I'll go over what all those cases are, but I think this timeline is really important, so I'm going to point back to it. So the en banc court said a person's digital life ought not to be hijacked simply by crossing a border. So you can guess the outcome of this case. It was in favor of increasing protections. So a little bit about Cotterman. Howard Cotterman was driving to the United States from Mexico when he arrived at U.S. Customs and Border Control. They seized his laptop in a response to an alert for a 15-year-old conviction for child molestation. Customs Border Protection denied Cotterman for 8 hours, or detained, Cotterman for 8 hours, but the initial border search turned up nothing. They found nothing. However, they decided to collect his laptop anyways to conduct a more thorough forensic examination about 170 miles from where the device was seized and where he was driving across the border. It was during that search, the forensic search, that child pornography images were discovered. So Cotterman attempted to suppress the evidence because of a warrantless search of his computer at the border, arguing that it violated the Fourth Amendment. The district court disagreed, but eventually the Ninth Circuit, en banc, said that this was not okay and that the border is not a place where anything goes. So generally, the government said that we have to account for the fact that more and more people are taking electronic devices across the border. We have to be more protective or more cognizant of the type of information that is on these devices, and so they're taking into the rights here of the Fourth Amendment rights of travelers. So here's the Ninth Circuit. We are in the Ninth Circuit now, so we have a heightened, when you travel internationally in or out to any airport or any border along Mexico or Canada, there is a heightened suspicion needed for a forensic examination. So it's not really clear what the court means by forensic examination. Does anyone here do forensics? So you guys would probably be able to articulate the point at which, it crosses over. The courts who don't have technical backgrounds, it may be a little more difficult. So they can likely still just inspect, a cursory inspection, click around the computer, etc., which I'm sure that anyone doing forensic is cringing because now someone's clicking around. But they only need a reasonable suspicion to actually escalate that to forensic examination. So bringing out my chart again, because I think it's really important to emphasize how little suspicion is needed, even though it's heightened. So I really like this quote, passwords and encryption are kind of a big thing right now, if anyone's following the news. And password protection alone of the files does not give rise to reasonable suspicion. So it's really great for the court to preemptively kind of say, just password protecting your files, or if they're doing a cursory search and they don't find anything, that having a file that's encrypted or password protected isn't going to escalate that to reasonable suspicion for a forensic search. So the Department of Homeland Security was not thrilled. They claim that a low standard of protection is going to actually be operationally harmful. And this may be true. I mean, I don't know. I don't work for DHS, but I can imagine it is going to make some cases' lives more difficult because they won't be able to do any searches basically on a gut feeling. So really quickly, I'm going to talk about Riley v. California and kind of why it matters in this context. So right now, the whole United States border, except for the Ninth Circuit, you need no suspicion. Ninth Circuit, you need reasonable suspicion for a forensic examination. So in Riley, the police located 2 guns and subsequently arrested Riley for possession of firearms. Riley had his cell phone in his pocket when he was arrested, so a gang unit detective analyzed the videos and photographs of Riley making gang signs. Riley was then subsequently tied to 2 shootings with ballistic tests, etc., and Riley moved to have this evidence suppressed. So here, the police officers relied on the fact of this other exception called the search incident to arrest, meaning they can search anything on your person for the officer's safety and for evidence preservation during an arrest. And so Riley disagreed with this and said, no, my cell phone is different, It does not actually constitute any harm to the police officer, and any evidence on there, the search without the warrant isn't quite warranted, because there are ways that evidence could be preserved besides just invasively going through the phone. So the court rejected the government's argument, and basically for the first time in a very long time, if not ever, a very long time, said that cell phones were a different type of container, that they held different types of information. So they said cell phones differed in both a quantitative and qualitative sense from other objects that might be kept on an arrestee's person. So in case law, generally, all containers are treated the same. You can have a box, and it's treated the same as a little box. It can say drugs on the side, or it can say innocent on the side. And, all containers are generally treated the same. Here, the court is saying, no, the cell phone is different. So, is it really different? The data a user views on many modern cell phones may be, in fact, not stored on the device itself, so they're not just searching the phone that's on the person, but data that is stored on another phone, and the court really struggled with this. They didn't like the idea that it wasn't information necessarily stored on the phone, and that it would be unclear to the officer actually doing that examination that that would be true. So, cell phones, as you guys all know, are designed to take advantage of cloud computing, and for the most part, it's turned on instantly. We had the celebrity hack, if that's what we'll call it, where individual celebrities didn't even know their phones were being synced, and so this is really problematic. And the court realizes that there are different privacy aspects around here that might expose more information to the government than was traditionally existed. Because you can imagine if you were going on an international trip, you weren't bringing with you all of your family photos. But now it's so easy, and with increased storage, why not? I see a question.
I thought the purpose of the search during an arrest was to protect the officer if he's hidden a knife or a gun or some sort of a weapon. And it seems to me like a cell phone is definitely not considered much of a weapon.
The court completely agreed with you. Yes, that is true. So the court completely agreed and said that the original rationales about this exception don't exist with regards to cell phones, and that there are other exceptions that exist that would still protect the officer if need be. For example, there's the exigent circumstances exception, which says, if the officer thinks that there is a exigent circumstance that might need an immediate search, they can't go get a warrant. For example, they may think the phone is going to set off a bomb, and they really believe it, and they can show retroactively that they believed that, and then they can go and search the phone. So if they really thought that the device was harmful, they don't need search incident to arrest. They have other circumstances and other exceptions which they can use. So again, rational to protect the United States. I'm bringing up this slide again because I want you to think about, here we had the United States Supreme Court overturn or modify the exception, the search incident to arrest exception, saying that the search of cell phones didn't fit the traditional rationales. And the question is, will the court feel that way about the search of electronic devices at the border? And that's unclear. However, border searches of containers at the border, that's really repetitive, excuse me on that one, have traditionally justified on the grounds that the search incident to arrest doctrine is very similar. Safety and the discovery of contraband. So digital devices can contain a vast amount of private information, which alters the fundamental nature of that search. And like cell phones, laptops are not weapons. So the Supreme Court specifically said cell phones with incident to arrest. We don't really know if computers fall under that. It's likely that the whole term electronic devices might be clarified. It's a really good argument. But generally, if they're feeling like a cell phone is this portal, that they would feel similarly about computers and hopefully extend that as well to the border. So I talked about this earlier, but exigent circumstances still available. So what does Riley tell us about the state of searches of electronic devices? Well, the court's analysis also suggests that it will balance the individual's privacy interests against the government's interest in crime prevention. What we don't know, however, is whether the Fourth Amendment protects from warrantless searches of all data stored in a cell phone, or whether it's limited to information traditionally considered private, such as private emails and confidential documents. We also don't know whether the Fourth Amendment applies to non-physical intrusions of a cell phone, such as the collection of metadata. So some real quick thoughts on forced decryption and password disclosure. So I've given a talk on this topic at ShmooCon, which if you'd like more information on that, I'd suggest watching that. But what's really interesting and worth pressing is that the Fourth Amendment warrant exception, in contrast to the Fourth Amendment warrant exception, the Fifth Amendment privilege against self-incrimination has no warrant exception. That meaning the border search exception isn't something that applies to your rights against self-incrimination. Those always exist, even at the border. And so if they do come across your computer with a password and tell you you must decrypt or you must turn over your password, if you believe you are in a circumstance in which you can say that you do not want to reveal this information in fear of incriminating yourself, which you do not have to be guilty to invoke that right, and you can invoke it at any time. You don't even have to be party to an investigation. You can do that, and that the border search exception doesn't prevent that. So I'm actually going through my slides pretty quickly, so we'll have lots of time for questions in case anyone has any. But let's say you've been pulled aside for secondary screening. How would you interact? Anyone can be detained, so don't take it personally. Maybe you're detained a lot. It happens. Be polite, courteous, and professional. I cannot stress enough, just in day-to-days, the more difficult you make it for them, the more difficult you're going to make it for yourself. And the harder it would be for a lawyer potentially in the future to argue on your behalf that you were complying, that you were being a good citizen, and you don't want to give ammo in a situation to make it worse. So, yeah.
So, say you are an obstructionist and antagonistic, what is the worst case scenario? Say that you have no other problem other than that.
We can talk about that after. So don't lie and don't obstruct an investigation. I guess the general thing is they can detain you longer. They can seize more of your devices. Maybe they wouldn't have seized your devices, and now they are, and they're going to keep them for 30 days because they can. They can make your life difficult. If it escalates, you possibly could be violating other statutes, committing other crimes, and that could fall into problems. For example, if you punch the customs officer, now that's going to be problematic. I would hope not, but you never know. Finally, protect your data, encrypt your hard drive. You guys know all these things. Carry less. I think that's always a big thing. And backup, because you never know if you might not have access to that device. And I think I'll just say a really quick thing. If you're interested about what's going on in this area, Laura Porteous had a lot of issues when she was doing various documentaries on the Iraq War and Afghanistan, and she was seized 40 times in 6 years, and she FOIA'd all of the documents about her with regards to the border search, and they turned back 6 documents. And for someone detained 40 times in 6 years, you can imagine there's more than 6 documents about you. And the Electronic Frontier has filed a suit asking for more information about that. And so if you're interested about that, I would encourage you to do a Google search because it's quite interesting. And remember, refusal to cooperate. I pre-answered your question. Lengthy questioning, denial of entry into the United States. I guess they could say you can't come back in. And so protect your ways that prevent awkward confrontations with Border Customs Patrol. If you think that something looks suspicious and you're not committing a crime, or whatever it may be, just be careful about what you bring. You don't want to have that awkward confrontation where you're saying, no, I'm not going to decrypt. And maybe you really have nothing worth hiding, but any natural person, and it's not necessarily right, but is going to say, well, I'm going to keep asking questions. I want to know more. Yep.
So if you're a dick, they could just permanently deny you ever coming back to the U.S.
I am not a border specialist in this sense, in immigration or emigration, but I can imagine they can detain you and keep you out of the United States for a period of time. Yeah.
So I've seen a lot of stuff online about these border checkpoints, like 100 miles into the border, 200 miles in. So obviously you're already in the country. Probably not going to let you turn around and go back between 100 miles in the country and right out the border of another country. So where does that leave you? They're going to let you go. Where you are participating in this.
Like, do you stay in Canada?
Well, if you're already in the U.S. technically, 200 miles in.
The border checkpoints in the United States, 100 miles in, are problematic in the sense that it's something that Customs and Border Control and Department of Homeland Security have established, but not necessarily something that the courts have recognized as truth. So it doesn't necessarily mean you don't have rights there, but it does mean it is a really gray area, and it will probably end up being either you comply or it turns into a court battle. I don't know. It's kind of just a gray area because they can claim 100 miles, but the courts don't necessarily recognize the border as 100 miles.
I just don't understand what them checking anything. I don't understand if you can cross that point or not.
Well, they could still find some evidence against you or something. Or they could be like, oh, then you're free to go.
Or not, but I don't understand what they gain if you're still in the country.
There are multiple justifications for why they set those up. They exist, so they must be there for a reason. Because it seems like a lot of staffing for nothing. Yeah, in the back. I don't know the answer to that question. We'll go back to my map. Oh, I'm on questions now. I'm sorry. They were going to have a mic come around, and you guys started asking questions right when I was done. So a lot of these technical what-if questions, in law school they teach you it depends. There's not really a good answer or a solid answer I can give you with a lot of these questions. They're all circumstantial. The law is very gray. The law is basically made around this based on incidents as they happen and as people pursue individual cases. Wait, I'll try to be good. Can you go to the mic? Because I know the people in the recording are going to be bummed. Oh, wait. I don't know.
Say that I go across the border and I make a point of doing a factory reset on my phone, like when I know I'm going to protect the area. And so, wherever we use that thing, we see the factory reset and wait to secure. Would that cause a problem? Will I be taking on my lawyer? Or if I do it before, like just with my land? And then a similar question would be kind of on the lines of there's like a lot of apps for phones that let you do like police watch where it says it basically streams the audio and the video to an external server. times, officers aren't necessarily willing to offer up their change there. They'll find different.
So those are all good questions with a lot of complicated answers. First of all, with resetting your phone or wiping your computer, there are evidence destruction laws. If you knowingly erase or get rid of evidence that or information that you think might be evidence to a case in the future, you could be violating one of those laws. If you have nothing on your computer that might be evidence and you're just deleting it because you're deleting it to avoid an awkward encounter, that might be different. It's really, really hard to say. As far as recording officers, if you politely ask to record the conversation, many courts have held that you have a First Amendment right to record government officials in their capacity as a government official. A lot of them are governed by state law, but at the border, there's a good chance that that's protected by the First Amendment. The problem is that they've already seized your phone at that point, so trying to record might be difficult. There's a story about Laura Poitras where they denied her a crayon or a pencil to take notes of the names of the officers in which she was being questioned by. So if you are in a situation where you're under secondary screening, it's definitely worth, I think in my last slide here, write down their names, write down any questions you may have, etc., document, and file a complaint. And it seems like not a great solution. That's probably the best and most legal solution that you can go by. I have not, yeah.
So when you get into this kind of scenario with secondary screening and in the scenario where they're taking your devices, do they typically record those interviews with you? Are those recorded and kept, and can those be referenced later if it does go to court?
Probably depends on where and when. I can imagine a lot of it is recorded, but can't say for sure, because there isn't a record of everyone ever gone under screening. Any other questions? Oh.
You mentioned that you might have a First Amendment right to record your encounters at the border. Mm-hmm. Every U.S. border I've ever crossed has had signs instructing you not to engage in any kind of recording. Are those just intimidatory, or is it unsettled as a question?
Unsettled. Yep. He asks whether or not just powering off or enabling encryption on your device would be the same as basically destructing. No, I think there's a distinction to be made there. How they handle it is really, it's hard to tell. These are a lot of great questions with a lot of what ifs, and the law is very gray. What does exist are these various rights in which you can assert after the fact or during it while it's happening. Sometimes they will disagree with where your rights stand, which is unfortunate. But as you can see in Cotterman's case, they took his computer, they did a forensic examination, and after the fact he argued that he had this right and created the case law. And so it's not perfect. They already knew he had these images. I think he actually still ended up going to jail, but they did throw out that piece of evidence for violating the Fourth Amendment. Or I think what they ended up holding is that they still had reasonable suspicion because he had this prior conviction. So yes?
Have there been any interesting court rulings or other legal precedents regarding multiple deniability? Because it's something I've read about but never looked into any court cases on or anything.
Not that I know of, but there are a lot of courts, so possibly, but not that I know of recently with regards to this issue. Oh, yep.
This is a little off topic. You said that for attorney-client privilege, that the border search does not provide you're not protected in attorney-client privilege ways during a border search. So does that mean that something that was discovered during that border search is now totally admissible in court, even if it was between attorney and client?
No, but with attorney-client is once the cat's out of the bag, it's hard to put it back in. So you don't ever want to expose that information, ever. So the privilege exists. You can accidentally release attorney-client privilege information, or it can accidentally be discovered, or it can be discovered illegally, etc. That doesn't, just because it's been found, doesn't mean that privilege disappears. There are ways in which you can waive that privilege, but in this case, the concern is that that information is now in the hands with other agencies, with other groups, and you don't know where it's going. And so as an attorney, you want to be cognizant of that. Most likely, but I can't say positively 100%. Yeah.
So to sum up, is it true that they cannot force you to enter a password?
Now, we're switching doctrines. That is unsettled law as well, but a couple of courts have held that, yes, in fact, you have a Fifth Amendment protection from putting in your password because it comes from the contents of your mind. So let me just distinguish that really quickly from fingerprints to unlock devices. They can force you to put your finger on a device to unlock. There is no privilege that you can.
But if you had something locked with a physical lock, they could force you to open it with a key you had.
Yes, and I see that where you're getting with the distinction. This is very off topic, but there are problems with that distinction with regards to encryption. Because, you can always kind of point to a key, but generally your password has to be, the contents of your mind is what's protected for turning over documents. And with regards to the active document production, which is what's happening when you're turning over a password, those privileges or rights may still exist if it's a key. So it's a more blurry concept than just physical key versus password. Okay.
Do you know how the U.S. border search exception and all the stuff we've talked about here compares when you're talking about other countries? Like, how do other countries do it? Are things vastly different, vastly similar?
When you enter their country, you are under their law. So the UK has been having a lot of discussions about the law on encryption and forced decryption. When you enter the UK, if they ask you to decrypt, you must decrypt. There is no Fifth Amendment right against self-incrimination that you can assert. So you are now under their laws. And so I think, if you go to a country, you say, UK border, and you're there, they make it very clear that you are no longer, in international waters or in your own country. So I think that's it. Thank you very much, guys.